Thank you. And I'm not sure who's going to lead off with the introductions of Brendon or Michael or both. Go ahead.
I can jump in to start. Yeah, my name is Michael Bach. I'm with IRIS, Institute for Research and Development on Inclusion and Society. And we do research and social development to advance the inclusion of people with intellectual disabilities. That's where we're rooted, but also from the vantage point cross disability and other marginalized communities. And formerly was Executive Vice President of the Canadian Association for Community Living for some years, and have had the pleasure of working with my colleague and friend Brendon Pooran on this issue for a long time. Over to you, Brendon.
Thanks very much, Michael. I'm Brendon Pooran. I'm a lawyer based in Toronto, Ontario, with a firm by the name of PooranLaw that specializes in providing support to people with disabilities, their families, and in community organizations in the disability sector. While most of our work is in Ontario, we do practice a bit out west in BC and out east in Newfoundland as well. As Michael said, we've spent many hours over the years working together on law and policy related reform initiatives affecting or involving supported decision making. So we're glad to be here with you this evening.
Okay. Thank you. So now that we've had some introductions, we're going to move right into this evening's presentation. And I believe you have a deck that you'd like to share and to continue on with, I guess, Brendon, you're leading.
Michael's going to be starting things off, and I think Laura, Michael and I met after we spoke and put together a little bit of a framework for tonight's discussion, and we kind of felt that it may be a little bit easier just to chat without a
sure, that's fine.
So I think we're going to approach it that way. Michael's going to lead off.
Okay.
Yeah. So, and we have I'm wondering how large a group do we have here?
I think we have 15.
15. Okay.
Mm-hmm.
And so also we invite people to, you know, as we go, we're going to keep this fairly short, the presentational part, so that we can, you know, have lots of time for discussion. But as we go, if people have questions or comments, really invite you to either raise your hand as we go or drop something in the chat. We'll either pick that up as we're talking or visit them later in the discussion. So we thought with this group, be good to keep it informal. My understanding in talking earlier with Laura is that there are a range of interests here and experience with the concept of supported decision making. And so we thought we'd do a kind of high level intro of concepts. Brendon will bring in on the kind of where we're at in terms of the legal regimes, legal framework in the country and some of the reform questions and challenges. And then we'll open it up. And I'm happy to share, you know, we're happy to share other resources and links as we go, as we get a sense from you of you know, the range of interests and priorities. So to jump off, what we're talking about today is what we might refer to as the equal right to decide. The right to exercise, in the language of the UN Convention, the right to exercise legal capacity on an equal basis with others. And by legal capacity, we mean the power to make decisions with legal consequences, enter contracts, give informed consent for health care, make personal life and property decisions. All those numerous daily decisions that make up our daily life. And both the small decisions, if you think about what you do in a day, so much of what you do in a day involves a legal arrangement. Often you know, going to the grocery store, going to the bank, these all involve contractual relations with other parties. And what we know is that people with intellectual disabilities, with developmental disabilities, cognitive disabilities, people with often with mental health issues, or some combination of all of those, have been systematically denied this right on the basis that they don't fully understand and appreciate, they're not able to fully understand and appreciate the nature and consequences of these various decisions and legal agreements. And on those assumptions, which have been embedded in our society, in our culture, in our law, in the Anglo-Saxon context for something like 600 or 700 years, on that basis, people have had their equal recognition as persons able to exercise legal capacity restricted or denied altogether. And so when we were involved in negotiating the UN Convention on the Rights of Persons with Disabilities back in the early 2000s, this was a real priority for actors, activists, disability rights community in Canada to get recognition of the equal right to decide embedded in the convention, and we did. And Canada actually led on this Article 12, as it's known in the UN Convention. And Article 12 recognizes the right to exercise legal capacity without discrimination based on disability. It obliges governments or state parties to the convention, and Canada is a state party, to have access to the supports they need to exercise legal capacity. And it also requires safeguards that all measures that relate to the exercise of legal capacity, and we're going to talk about some of those measures, must respect the rights, will, and preferences of persons with disabilities, of all persons. The UN Committee on the Rights of Persons with Disabilities, which has interpreted the convention, which that's its job, has issued a comment, what they call a general comment on Article 12, which makes very clear that the interpretation of Article 12 in international law is that people have universally people have capacity, that you can't deny a person legal capacity because they have an intellectual or cognitive or developmental disability, no matter how significant that disability is. That is not a valid reason. And so what the convention did is it disentangled, it disequated, if you will, legal capacity and mental capacity. And those two have been completely bound up together. And if you look at legal provisions in cross jurisdictions in Canada and around the world, that's the main problem we're facing, that it's assumed that exercising legal capacity is all about having the mental capacity to understand the nature of decisions and appreciate consequences. What the convention has done is pulled that apart. It's not that there doesn't need to be appreciation and understanding for a legally valid decision, but we can draw on support of others to bring that understanding and appreciation. And so what's, I think, at the core of this, what Louise Arbour, actually, who was, a Supreme Court justice, went on to head the International Criminal Court in The Hague. She said it at the time that, this was a fundamental paradigm shift in the law. And I think it's important to think about what that paradigm shift is. And I think that at the core of it is this idea that what makes us persons able to exercise our will, deserving of respect, to have power over our own lives, deserving of dignity, on an equal basis with others, in the eyes of others, is not our intellectual capacity. It is that fundamentally we have things that we care about. What makes us a person is that we have things that we care about, things that matter to us. And those, if you think about things that are most important to you in your life, it's not things that you think up. It's things that you feel. what we care about are things that, are whatever way you think about your core being, it's your soul, it's your heart. Um, these things develop in us, and everybody has that. And we know that from our experience of loved ones, family members with intellectual developmental disabilities. People have things that matter to them. And so what this new paradigm establish is that is the ground of legal capacity. My will, what I care about, is the ground of legal capacity, and this I may need then supports to exercise that, to interpret my will and preferences into a set of decisions. And that's the step that we haven't yet fully made in law reform. Is to establish a legal regime that starts from this understanding that what makes us a person, what should drive decision making, is the core concerns, the things that matter to me, that I want, that I don't want. And we know from our experience, whether we have whether we have a disability ourselves or loved ones and friends, that we support each other to help achieve the things that matter to us. And we often draw on others, loved ones, family, friends, who can often help us see the pathway to achieve things that we want, sometimes better than ourselves on our own. And supported decision making, that's what the supported decision making is all about for people with more significant intellectual, developmental, cognitive disabilities. Some might refer to as profound, people who wouldn't meet the usual mental capacity test that has been the basis for legal capacity. Supported decision making starts from that place and says, okay, well, how do we understand what matters to Michael? How do we interpret his will and preference? And how do we then figure out all the steps that need to be put in place in order to deliver on that? I don't think I need, I know folks in the session this evening, I'm sure in your own relationships or as a you're involved in doing this in your daily lives and the lives of people you care about and support, or who are supporting you. And that's all that we're asking the law to do. We're asking the law to recognize this way of supporting one another in decision making. Practically, what that means and what our law reform proposals have been calling for is that the law recognize what we've referred to as two broad pathways for decision-making capability. So we understand decision-making capability as having the capability to act on those things that matter to you, act on your will and preferences, and have the support to do so. And there's kind of two pathways that we're calling on the law to recognize. The first is what we refer to as independent decision-making capability. And that is the presumption in law that I should be able to make decisions by myself, that the presumption that I might need some support in understanding and appreciating the nature and consequences of a decision, but the presumption should be that I'm going to make my decisions independently. I may draw on the informal support of others, as I do in my own life right now, but I'm not required to. The law enables me to enter a contract on my own, to meet with the doctor by myself and make my healthcare decisions on my own, provided the doctor, medical professional feels I can meet the test of informed consent. The second, and so the law is developing in Canada and elsewhere to recognize that people with disabilities may need some additional supports to act independently. They may need more time in the appointment with the healthcare provider. They may require, when they go to the bank and they're trying to manage their accounts, they may need both more time. They may need someone at the bank who can translate the agreement into plain language for them. They may also need an advocate because they feel a bit intimidated when they meet at the bank or go to the healthcare provider. But at the end of the day, that third party is confident that even though I have the advocate and they've translated into plain language and we created some more time so that, you know, maybe I go to 3 appointments with the doctor before I make, you know, we reach a healthcare decision. At the end of the day, those parties are confident that with this support and accommodation, I can understand, you know, what this decision is about. It reflects my intentions. It reflects my will and preferences. And I appreciate the, you know, I can appreciate the consequences, the risks and what's at stake. That's independent decision-making capability, and the law largely recognizes it. And the reforms that we're seeing are about beginning to recognize that people may need this additional assistance and support. Because we still have all kinds of cases, and Brendon can share some of these examples with you where we've got people who you know may need a little additional support, but because of the stereotypes that come with having a developmental or intellectual disability, the assumption is that they can't make decisions for themselves, and so they're placed under substitute decision making or guardianship and lose power over their own lives. So we're beginning to reform and see some reforms there. The second pathway that we're looking for the law to recognize is what we refer to as interdependent decision making, and this has been, you know, kind of where supported decision making started back in the late 80s, how to support people with more significant, profound cognitive or developmental intellectual disabilities. And by interdependent decision making, what we mean is that I may not have the decision-making skills and abilities to understand and appreciate, but I do have things I care about, and I can communicate those in a ways that at least one other trusted person can understand, and they can interpret my will and preferences and translate those into the needed decisions in the circumstances. So, you know, we use the example of, you know, I have pain in my tooth. I can communicate that I have pain and that I want that pain gone away. I may not meet the test for informed consent when we go to the dentist, but my supporter can build the link. They can interpret my expressions and my will to have my pain go away, and they can translate that, if it's not already obvious, to the dentist, and we need to figure out ways then to make that intervention happen, to extract the tooth or fix the cavity or whatever. Those situations have been used as the reason to strip me of legal capacity and the right to decide. What we're calling for is that the law recognize this unit that is made up of me expressing my will and me having around me trusted others to interpret my will and preferences into decisions needed in the circumstances. That's what traditionally supported decision making was referred to. But now supported decision making sort of is, you know, could be for independent or interdependent, but we don't need to get into discussion on terminology at this point. Those are the two broad pathways we're calling on the law to recognize. We're beginning to see this. There is some beginning to see it recognized in Canada. Since the CRPD, the UN Convention, it's probably been most comprehensively recognized now in Colombia and in Peru, where they've abolished their guardianship and substitute decision-making systems in favor of supported decision-making, even for people with more significant developmental intellectual disabilities. And there's reforms in different parts of the country. We've got various law reform proposals to make this happen, and Brendon can also speak to some of those. But I'll pause there and turn it over to Brendon to kind of give a bit of the legal context that we're in for advancing and making progress on putting these approaches to decision making into law. But those are the core concepts that drive our work. Over to you, Brendon.
Thanks very much, Michael. You've really sort of framed this out nicely for us, and I'll try to follow up now with a few comments related to sort of the legal frameworks. The main challenge here is that the law relating to legal capacity does reside within the provinces and territories, and so while there are provisions within federal legislation that address sort of consent capacity and legal decision-making requirements, the provinces have the jurisdiction to develop the legal frameworks governing this area of the law. And so what we've seen evolve over the years is sort of a patchwork of different types of legal frameworks that apply to people depending on where you live. We, as I mentioned, reside here in Ontario, so I can speak to the law as it relates to Ontario sort of in depth and have a general understanding of sort of the legal frameworks across the country as well. There's, generally speaking, every province has a substitute decision-making framework in place. So here in Ontario, we've got a piece of legislation called the Substitute Decisions Act. And that piece of legislation governs all matters related to guardianship and powers of attorney for the most part. Here in Ontario, the law, in a sense, is very black and white. So it's either you are capable of making a specific decision or you're not. And if you're not, then somebody who's referred to as a substitute decision maker replaces your right to exercise your own decision-making capacity. They step in your into your shoes and make a decision for you. I'll come back to Ontario in just a second. In other jurisdictions, most of the jurisdictions also have supported decision-making laws in place, but there are a few jurisdictions across the country that have introduced alternatives. And I think Michael would agree with me that none of them are necessarily perfect. But at the very least, they do provide, they do encompass some of them encompass a few of the characteristics that Michael has been describing and calling for with respect to law reform in this area. I would say most notably out in British Columbia, there's the Representation Agreement Act that's been around for years. And representation agreements, again, although they're not perfect, they are supported decision-making, or characterized at least as supported decision-making planning documents that do, in the legislation, explicitly recognize the will and preference of the person themselves. So in other words, a person can enter into a representation agreement with a trusted friend or family member who's able to interpret their will and preference, and that representative is then there to support the individual in making their own decisions. And the Yukon allows supported decision-making plan documents as well in their legislation, or in its legislation, which is the Adult Protection and Decision-Making Act. It's similar to the legislative framework that's in place in BC, where an adult is considered capable of entering into a supported decision-making agreement if they understand the nature and effect of the agreement. In Alberta allows what they refer to or characterize as supported decision-making planning documents, but those documents relate to personal care decisions only. And in Saskatchewan, Saskatchewan has the Adult Guardianship and Co-Decision-Making Act, which allows court-imposed decision-making support relationships, but does not provide for supported decision-making. So those four jurisdictions have some additional options to your typical sort of substitute decision-making instruments, which are primarily grounded in guardianship orders, guardianship orders either issued by the court or through the province's public guardian and trustee's office, or power of attorney documents that typically require the person to meet certain legal thresholds before entering into them. So here in Ontario, we've got two types of power of attorney documents. We've got one relating to property and another relating to personal care matters. And personal care matters cover healthcare, hygiene, nutrition, safety, shelter, and clothing. The issue is that not all people are considered to be capable of entering into those agreements because they don't meet these legislative thresholds. So the threshold is especially very high on the property side, whereby somebody needs to have a sound understanding of their assets and liabilities and income and expenses and obligations to dependents, et cetera, in order to even be able to enter into a power of attorney arrangement, which would allow them to appoint somebody that they trust to manage their affairs during times of when they would deem to be incapable. So power of attorney for property documents are not an option for many people out there, especially those who may have a developmental or intellectual disability. On the personal care side, the legal threshold is a little bit lower, but still people need to understand the nature of the agreement, the fact that whomever they're appointing is acting in their best interest and may have to step into their shoes and make a decision for them. So for that reason, you know, and Ontario is similar to many other provinces, this creates a lot of challenges for people when they want to carry out sort of everyday activities that you and I may take for granted. So such as opening up a bank account, making healthcare related decisions. When we talk about matters that are specific to disability, an example that we always bring up is accessing the RDSP, or the Registered Disability Savings Plan, which is a fantastic long-term savings plan designed specifically for people with disabilities that was introduced back in 2008. But there are provisions within the governing legislation which essentially say, if you are an adult looking to benefit from the RDSP, and if you are considered to be incapable of signing a contract, then you can't manage your own plan. And the only people that can manage a plan for you are your parents, your spouse, or your common law partner. Some provinces and territories have amended their legislation to provide for other options. In some provinces, this isn't, like BC, where the Representation Agreement Act exists. This is not an issue. But here in Ontario, that means that many people who would be otherwise eligible for the RDSP are unable to open those plans unless they become subjected to a guardianship application, which means that all of their rights are taken away, given to somebody else, just for the sake of opening up an RDSP. We're finding that this is a barrier for a lot of people when it comes to accessing certain types of individualized funding agreements. Again, using an example here in Ontario, we've got some funding available through what's called our Family Managed Home Care Program that is delivered by the Ministry of Health. Ministry of Health says if you're incapable of managing property, then only a guardian can manage that property for you, unless at some point you were able to execute a power of attorney for property and appoint somebody that way. We have many people who may want to serve as a director of a corporation. They may be a member of their local community living organization, or they may have a microboard or something similar in place, and they want to be a director of that corporation. Well, in most provinces and territories, the legislation explicitly requires that people have the capacity to manage their own affairs in order to act as a director. So these are just some examples, some everyday challenges that people face as a result of gaps in legislation or lack of options of legislation that allow people to, or that really recognize a supported decision-making relationship. As Michael said, and I'll sort of wrap things up here in the next couple of minutes to allow for questions, but as Michael mentioned, there are a number of law reform initiatives taking place around the country. Here in Ontario, our Law Commission of Ontario was charged with looking at guardianship legislation a few years ago. They issued a report, for anybody who's interested, I think back in 2017, if I recall, March 2017, which included about 62 or 63 recommendations. Unfortunately, the report didn't include any strong recommendations related to supported decision-making, but it did open the door a little bit in terms of recommending that pilot projects be embarked upon to explore supported decision-making options. And with that, actually, Michael and I have been involved with the provincial community living organization in developing some pilot projects across the province. Michael, maybe you can speak a little bit to some of the law reform initiatives taking place in New Brunswick and Newfoundland as well.
Yeah, thanks, Brendon, for that overview, and maybe just which gives a kind of snapshot. And as Brendon says, you could go into a lot of detail. We are seeing some promising initiatives in both New Brunswick and Newfoundland and Labrador, with commitment at the kind of Ministry of Justice level to recognizing this, what we've referred to, as the interdependent approach or supported decision-making approach for people who don't meet the capacity test, as Brendon has outlined it. So there's been commitment, political, bureaucratic commitment. We're beginning to see some formulation of potential provisions. So that's actually pretty promising, given that in some other jurisdictions, those reform efforts have not proceeded and have sometimes actively been resisted. So, as with other kind of major policy and law reform effort changes in Canada in any number of domains, if you can get it sort of into one province, it becomes a benchmark for others to pick up. So that's really been our focus. But maybe Brendon, we should pause here and just kind of open it up. And
sounds good.
Yeah, and any questions on the concepts, the approach, or there may be trying to make sense of a particular situation that you're aware of or involved in, or ideas about how you can be involved in helping to move this agenda forward. Happy to engage in all of that.
Okay, so I'm going to jump in because we do receive a number of questions about these issues. And one of the things that I feel is that generally there's confusion about what it really means. People are told, this is what you have to do, and if you don't do it, you can't get funding, you can't get access, you can't, there's all these can'ts that a family has to make a guardianship application, which is costly. And some of the challenges in the how-to piece around the guardianship application, if you could talk a little bit about that process itself, how long it takes, what kind of costs we're looking at to start things off.
And maybe over to Brendon, and also Brendon, what are the alternatives? What do you do at that point? Because I hear that, Laura, we hear that as well. What do you do at that point where you're told you have to go this route?
Yeah, and I think it really depends on the decision that needs to be made, right? Because unless somebody goes through a formal capacity assessment, like there's a myth that there's this global label of incapacity or incompetence, right? And there isn't, unless someone is subjected to a formal capacity assessment and that label is attached to them. So when it comes to considering whether or not somebody is in quotes capable of making their own decision, that decision is time and decision specific, right? So when we talk about alternatives to guardianship, we have to talk about it within the context of what is the decision that is being made. Because, for example, here in Ontario, if somebody was applying for social assistance benefits, if they're applying for benefits under the Ontario Disability Support Program, even though those benefits include the management and administration of monthly income support payments, ODSP has an informal process in place where it does recognize a trusted family member or friend to assist with the management of those funds, right? Like guardianship wouldn't be required in that case. If we're talking about opening up an RDSP, the example that I used a little bit earlier, and the bank, in the bank size, the person isn't capable of signing a contract, and the person doesn't have a parent, spouse, or common law partner to help them open up the plan, and they don't meet the legislative threshold to execute a power of attorney for property, then there is, unfortunately, in that situation, no alternative to guardianship. So it is really decision specific.
Okay, thank you. I'm looking at the chat here to see if there's any questions in there. Otherwise, I can carry on. Maybe an opportunity for folks to open up their camera video if they like, or to put their hand up by clicking on the reaction on the bottom toolbar, and we can address questions that you might have. There's one question in the chat here from Tracy. If an RDSP has already been open for several years, does that pose a problem?
Well, again, it depends on how the RDSP is set up. So if the RDSP is set up in such a way where the beneficiary of the plan is also the plan holder, right? So if it's the person with the disability that's actually the plan holder, then it doesn't necessarily pose a problem. If the RDSP is set up in such a way where, let's say, the parent is the plan holder, it does pose a problem, because what happens to the plan when the parent passes away? Right? If the bank doesn't think that the beneficiary is then capable of carrying on with the management of that plan, that RDSP could be in jeopardy. And so that's what we're seeing a lot of these days. As parents pass away, they are plan holders of the RDSP. And what that's doing is that is triggering numerous guardianship applications, right? Because people don't want to lose their RDSPs. But the only way for another trusted family member or friend to step in, or not, the only way for the RDSP to continue is for a trusted family member or friend to step in, apply for guardianship, and manage the RDSP.
Okay, thank you. Laura has her hand up. Laura?
Hi, thank you. Nice to meet you. Sorry, Brendon. So what you're mentioning is that the RDSP can only be opened by either a parent or a guardian?
So sorry, the caveat here should be, I'm speaking with an Ontario lens. So yes. Which province do you reside in?
I'm in Ontario, in Oakville.
In Ontario. So if we're talking about, and how old is the beneficiary?
55.
Okay. So RDSPs can still be open for 55-year-olds. You have until 59, but they're not going to be eligible for any of the government grants or bonds, because that ends at 49. But for a 55-year-old, if again the bank considers them to be capable of signing their own contract, they can manage their own plan. If not, then unless they have a parent, spouse, common law partner, attorney for property, or guardian of property in place, they can't.
Okay. Thank you.
Sure.
Thank you. So I'm going to ask another question, because, you know, a lot of these power of attorney documents can be done through the mail. You know, you download a blank copy of it and you execute it and you take it with you. And how would somebody know, you know, you're sort of depending on the knowledge base of the person that you're approaching if you do present what appears to be appropriate paperwork. How does that work?
Well, cognizant of the fact that you're recording this presentation here, Laura, here's my answer. Really, at the end of the day, the other party may not want to accept. It's up to the other party as to whether or not they're going to accept the power of attorney document.
Sure.
Right. So, you know, it may be that depending on the nature of the transaction, the party may require a notarized version of a power of attorney document, or not. They may not, right? Like the downloaded power of attorney form may work, but I think if we look at that, if we look at the fundamental issue associated with doing that, I mean, really what power of attorney documents are meant to do, the power of attorney documents are meant to provide somebody with a choice in terms of who they would like to appoint to act on their behalf, right? I mean, I'll use the word support here, to support them, even though it's not a supported decision-making vehicle. So we've got to be very careful. I think it's a bit of a slippery slope if we, you know, sort of suggest the family members that they just kind of download a form and you know, facilitate the execution of that document, the signing of that document without the grantor, their family member, fully understanding and appreciating what they're signing.
Sure. So across the board, you might recommend that anybody has some concerns over circumstances like this would consult with a lawyer?
I would hope not. Like, I would hope that they wouldn't have to every time they hit a bump in the road. And I mean, that is the fundamental issue, right? Because at some point, a family member may say, like, I'm tired of having to speak to managers or find workarounds or consider downloading a form or doing everything online. Like, I just don't want to have to deal. I'm just trying to support my family member, right? And so they may decide that at some point they just want to go through the guardianship process, unfortunately, which obviously has significant ramifications and implications on their family member. But that may be the only way for them to proceed. I would, however, say that, and this is more anecdotal, but like, we support thousands of families, and it's got to be less than 0.5% of those families that actually pursue guardianship, because given their family member circumstances with respect to their income, their assets, and the types of personal care decisions that they require support for, they're generally able to operate within the context of the law. Sometimes not easily, but at least without having to pursue guardianship.
Great, thank you. Laura, do you have your hand up again, or is it still up from before?
Oh, sorry, still from before.
Okay. Anybody else have a question from the chat? I'm just taking a look here. I don't see anything in the chat. What about somebody a parent who says, well, I'm their guardian, having really a misunderstanding of what that means when they have not actually had official court-appointed guardianship. Any thoughts about that?
Yeah, and Michael, feel free to jump in here if you've got any thoughts. But I mean, that happens quite often, and understandably so. I think many parents just assume that they've got guardianship with their kids, regardless of whether or not their child has a disability. I think many parents are shocked to realize that they are never guardians of their children's property, right? Unless the court has appointed them as such, regardless of their child's age. And again, this is regardless of whether or not their family member has a disability. So I think we find here in Ontario that a lot of, quite often the terms guardian and power of attorney and substitute decision maker kind of get used interchangeably, not only by family members, but by healthcare practitioners and by folks at the bank and educators and, even lawyers and accountants. So it's not the easiest area of the law to sort of understand, but I do think it's important for family members to attend sessions like this, so they're able to sort of gain a little bit more exposure in terms of what these terms mean, but more importantly, what the alternatives are to guardianship, because many of our families are encouraged by external parties to pursue guardianship. And most of the time, it's not required.
But it is being actively promoted through the education system by service providers, sometimes by community service providers who see in guardianship a way to manage liabilities and to ensure that they've got decision-making authority, or they've got someone with decision-making authority when a person might be questioned. So I think it's really critically important that actually, associations like yourselves, which have networks and links to families, if there's a way that, and this is a great opportunity that you've created tonight, there are a lot of resources that we can share, that you can point people to, but that education and awareness function is really critical. And it's like advancing inclusion in any other area, whether it's employment or education. It changes because people demand the change. And so, looking to generate that kind of momentum from civil society groups like yourself is really key. And we're happy to share resources to assist you in that.
Great, thank you, thank you. It's interesting that we, in our resource library, we've developed sort of workbooks to help people manage, or to help to put their thoughts together where they may need some help to do that. And we are familiar with a number of resources that actually help individuals with intellectual disabilities to put their thoughts and feelings in writing as best as they can understand it, with or without support, so that then they could take that to the doctor with them, or to the bank with them. That might be a very good exercise for all families to undertake at certain ages of development, rather than making the assumption, as Brendon alluded to, that, oh, I'm my parent, I'm my child's guardian, that could not be challenged. Would you recommend that families, individuals prepare something like that in the event of some decisions they might have to make where they're not, have nobody with them?
Yeah, I think, again, it's sort of decision specific. I think the way I would sort of frame it is, you would want to try to engage with your family member to assist them with perhaps getting their wishes down on paper, right? Because what often, I shouldn't say often, what sometimes happens is that, parents may not see eye to eye with their family members as they sort of grow up. I may want to live somewhere else, eat something else. Unfortunately, we are involved in quite a few cases where we're actually representing the person with the disability because their family member has taken some sort of legal action against them, or they've taken over the management of their property and they're misusing those funds. And so, while I do appreciate the challenges that especially parents face when they're trying to support their family members, I think it's important to try to, sort of elicit the wishes of the person themselves and try to document them, because most jurisdictions have legislation which essentially says, if I'm in a substitute decision-making role, I have to act based on the prior capable wishes of my family member before I consider best interests, right? Best interests shouldn't be paramount. It should be any decision that you are making on behalf of somebody, or any decision that you are supporting somebody to make, should be reflective of their will and preference, or what they want.
Okay.
Not sure if that made sense, but
yeah.
I think there are also some tools, I'm thinking of some out of British Columbia and elsewhere, where people write down, with the individual, and this is for people with more significant disabilities, ways the person communicates, things that are important to the person, how the kinds of things that are helpful in decision-making processes, so that it is talked through, it's documented, and then while that, which is really the basis of a supported decision-making agreement, while it might not have legal authority, it might help push, kind of encourage the third parties to respect that process and to respect the ways that that person communicates, that effectively gives them power over their own lives and enables people to enter, agreements on that basis. And we've got all kinds of parents in Ontario, family members with significant intellectual disabilities, who have taken this approach, and have built the relationships and the understanding of their son or daughter, brother, sister, and have kind of pushed out guardianship absolutely as far as they can, until there comes a point at which another party won't enter an agreement with them, and they have to go that route. But I think putting it down, and there are tools, we can send you some links to some of those, to assist, is a really, really helpful step.
Hey, Michael, and it may carry some legal weight, right? Because it could be characterized as an accommodation, right? And the duty to accommodate is built in to human rights legislation in every jurisdiction.
Yeah. And we are just on that. We are working right now with the Human Rights Commissions from BC, Ontario, Manitoba, Newfoundland and Labrador, and the Canadian Human Rights Commission on a guideline for the duty to accommodate the exercise of legal capacity, so that would begin to articulate how to apply the duty to accommodate to this area, so it'll be a tool to educate individuals, families, but also third parties about their responsibility to adapt decision-making processes. We're not there yet, but we're working on it. We'll get it to you.
Thank you. Gordon, you have a question.
Yeah, great presentation. So I really appreciate. It got me thinking about a lot of stuff. So appreciate the depth and the preparation for this. I guess a question and a comment. Maybe Brendon, or I guess both of you, are you seeing that there's any invitation on the part of the federal government to look at the whole qualified family member as part of the RDSP? I think last I heard it kind of expiring in 2023, and they've kept just renewing it. But I think the original promise was that, hey, we're going to come up with something in this vein, right? That would be maybe a little more expansive. And then I guess the comment would be, I'm assuming the answer is no, you haven't heard anything. And is this maybe an opportunity for advocacy? Is kind of what came in my head as I'm listening to you, because that's the federal government, and that may have some suasion on the other provinces if we can develop a mechanism to deal with a very real problem. And Brendon, I'm seeing the same thing from Alberta, but seeing exactly the same thing with regard to RDSP. So I think you've highlighted an important problem, but maybe there's an advocacy opportunity to try to influence the federal government to say we should do this. And maybe that would be a tipping point for the provinces to take some action.
Yeah, no, great suggestion, Gordon. We're on year 14 of trying to shift the feds, and we haven't given up. So yeah, we've got a couple of pathways that we're sort of exploring right now, but happy to connect with you on that, because in an ideal world, there wouldn't be a patchwork of solutions developed across the country when it comes to the RDSP. It's a federal program. From my standpoint, at least, the federal government has the authority to encroach upon provincial jurisdiction here when it comes to addressing legal capacity related issues related to the RDSP, and they have done so, right? They have done so by virtue of expanding the definition of qualified family member, and so we're just asking them to identify some additional options and to potentially even broaden that definition. So happy to connect with you on that.
Yeah, no, it's good. I had the delightful opportunity to actually talk to Minister Flaherty when the late Minister Flaherty on this topic, and I actually point blank asked him the question when it first came out, what are you going to do on that? And he goes, well, it's provincial jurisdiction. We can't control the provinces. Then he paused and he said, but as the finance minister, I have a lot of suasion. So anyway, for what it's worth, at least him being a parent of a disabled child understood the nature of the problem, and maybe we can hark back to some of those. I think the heart was there to do something more than maybe what exists. So yeah, just encourage the advocacy efforts on that, because that may be a good place to start to convince the governments because it's, but again,
yeah. I mean, he was very supportive, Gordon, and put in place that opening up the opportunities for family members without having someone declared contractually incapable. But and the hope was and supported bringing various provinces and territories together to come up with a solution. But at the end of the day, they kept deferring, and I think until we get over that to the provinces. And Brendon's doing some work, on some legal work. As he said, thinking this through. I think it is about an advocacy effort. Also, the UN has called out Canada for not taking the leadership that it needs to address the patchwork of legal capacity provisions across the country. So this is very much on the agenda. There are some buttons that we can push, and would be great to have your support, your collective support in this effort.
Okay, thank you. So I'm going to stop the recording, and I'm wondering if perhaps there's anybody else who might have a